Freeport warehouse. What I've given you is the statute that regulates the Freeport, the filing, and what's required by the statute. The second page is a little detail on what's required, how they're required to report their inventory. The next is the blank forms that's required by all Freeport warehouses to report their inventory. You have one that is for the estimate of their inventory for the beginning of the year, and then you have one that explains their movement of inventory for the year. Okay, on the law states that, for the statute, requires that each warehouse report their inventory every year. That's a requirement. They're required to report that every year. They're to give an estimate of what their inventory is going to be, and then you have the movement form, which is filed the next year, that tells exactly how much inventory went through that location. It's also stated in the statute that each warehouse is required to keep accurate records of their inventory and to report that inventory to the assessor's office, because the assessor's office uses exactly what they report to establish their value. Okay, and that is what we did. The next forms you'll find is the form that Milwaukee actually rendered the value that the assessor's office used to establish our value for 2010. And it goes on with all the different documentation. For 2011, when they filed their forms for 2011, then that is when they was able to show their overestimated value for 2010. When there's an overage, the company is not assessed. It's their loss. But when they're underestimated, then the assessor's office back assess the value that they have understated, and the collector's office collect based on that under assessment. That's what the law or the statute, that's how the statute works for the filing for Freeport every year. And again, each company is required to keep accurate information, and they're required to report to us these two forms every year. Let me add to the fact that Milwaukee have not, within their 5-year period, in my research, they have not properly filed the documents that is required for the Freeport movement. If you notice on the second form for the 2009 movement, it's incomplete. So there's really no accurate way for us to know if the figure that they gave us for the 2009 back assessment is in line with what the inventory that they had in the previous year. That's one issue that came up in this search. Also, when they file these forms, the form is like a sworn statement. When they sign these forms, they're saying that all the information that's on these forms are true and correct. And again, that's what the assessor's office works based on the information that has been provided to us from the taxpayers, from the taxpayer themselves. Okay, another thing the gentleman, Attorney Pace, mentioned about the Freeport being in place. Again, it was not in place, but we didn't really, the assessor's office, that didn't come into light until their Freeport filing arrived at our office past the deadline. Each Freeport filing is required to be either postmarked or in the assessor's office by March 31st. Anything after March 31st, the exemption for the Freeport is canceled. Then we assess on the full amount. If you look at the form that says report of inventory, January 1, 2010, that was filed by Milwaukee. Had we received this form prior to the March 31st or post-March on March 31st, their value would have been based on the $345,774. That would have been the figure that they would have been assessed on had we received it prior to the deadline. But since it was received after the deadline, we taxed on the full amount of the inventory. Another thing he stated about the timely manner, the county mailed out an assessment notice to all companies when the value increased 10,000 or more. You'll see in your pack there is a printout that will provide by the data processing department a printout of all the appraisal notices that are mailed out. We mailed them a appraisal notice stating, giving them the way that we were going to assess them for the 2010 tax year. During that time, all taxpayers can it was mailed to the same address that all the other correspondence that's mailed out. The first.
I see
it went out like the 1st of August.
Okay.
Because we had 2010. Last year was an awkward year for the county. We were running behind in time to get our 25% done. Short-handed in the assessor's office. We were granted an extension. So where normally the taxpayer has the informal time to protest to the assessor's office, which normally is the whole month of July. This time they had the month of August, and then the protest hearing was in September. They did not contact our office. And the procedure is, if they don't file a formal protest with the Chancellor Clerk's office, then all the values are set. That they have passed their time to appeal the value that we have established. And another statement Mr. Pace made as far as them knowing that the Freeport filing was not in place, they would have filed just a regular rendition. On their regular rendition, they filed 0. So it still would have been some kind of something was wrong, as far as their filing with their in their reports. So my thing is, like I said, the tax assessor's office have tried to follow all the guidelines that are put before us in handling this company like we handle all other companies.
I guess going back to Supervisor Graham's questions, what did they know and when? They knew there was an assessment of 57 million, which was by them as of August, when the values were set. And the first correspondence or contact, from what I understand from Mr. Pace, to the county with regard to that was in December of 2010, when they actually received it. And by then, the time period had elapsed for them to formally protest the assessment.
Was their assessment fairly consistent, like from 05, 6, 7, 8, 9?
Well, that's the thing about it. From his versus research, the last time they filed a value for assessment with their rendition was in the year 2006. And so you have a jump from 2006 to 2002.
Actually, 2 years that they did not file at all. So the value carried over from the previous And since their movement forms, they have not filed movement forms, it's really hard for us to really say that it's out of line. Enough, yes, it is high, but based on our records, there was really no way for us to say that yes, it is way, way, way out.
So if you didn't know it was a mistake, you couldn't correct it because you didn't know it was a mistake.
Correct.
So you can't correct it unless you know.
That's right.
Ms. Kevin?
Did I hear you correctly that any time a company's assessed value exceeds 10%,
10,000.
or 10,000, and it was 10,000 or more, that the office sends out notification
Yes, ma'am.
to allow that company to come back and request a formal protest?
To request us to look into it, for them to provide us additional information, for us to try and work through, whatever the problem is. And during that time, if we're still not at agreement, then they can file a formal protest with the Chancery Clerk's office. And that would allow them some additional time for us to work together and try and come to some kind of agreement.
And that's one of the things that the office does as a courtesy. There's nothing in the statute that tells us that we have to send them out. But that's being fair to the taxpayers to alert you that this is the value you'll be facing coming into your next year. To give them an opportunity to call us, to come sit down, to bring documentation, to explain their point of view and what we're looking at. And like Laura just said, if we don't agree, then we would ask them to go up to the Chancellor Clerk's office, file a formal protest in writing, and invite them to come to the protest hearing so the board can make that decision.
Ms. Kevin?
Likewise, another question to make sure that I understood you correctly, and that is Milwaukee has not filed properly in the past 5 years accurate reports.
For 2006, 2007, they did not file at all. For 2008 and 9, they only filed the one part of what's required. There's 2 forms that's required to be filed, and they only filed one. So, yes, there's been some slack in the way they've been filing.
Mr. President, I'm prepared to.
What role does the Economic Development Authority play in this whole scenario?
Well, really nothing other than just the same types of facts. I mean, when companies come in, we will negotiate the incentives when they come in. Of course, the incentive for this company was a free board. And I guess when we boil it down, when you get down to due to the record keeping and things, they're correct. There's really no way for us to know whether or not this number is significantly different than what another year may have been.
Now, let me back up. Now, you handled the report. We read section of
At the beginning of a incentive program, bringing in a new company, reports are part of our negotiations. And then the renewals, sometimes they will come through us, and sometimes they don't. But what we would check if a renewal came through us is we would ensure that the company is still doing what they promised to do in the initial agreement. And if they are, then we grant report. If they're not, but they're doing some, we may grant a partial report because you don't have to do 100%. You can do percentages. In this instance, you know, the only thing that we really had to look at the district is, was your intent for them to have a Freeport warehouse? Would you have renewed that Freeport warehouse had it been filed in the timely manner? And I submit to you that you probably would. I don't get into the law part of it and those things. The company freely admits that they did not, get their Freeport warehouse license on time. That's a fact. I guess the law does allow them to come before you and ask for you to go back and look. And what I'm going to ask you to do is look at what you would have done had everything been filed properly and correctly.
Well, this is the thing, and I've tried to state this initially, and I believe Attorney Pace agrees with me. The board is prohibited by law to execute a Freeport warehouse.
No, I'm not talking about the Freeport. No, I don't want you to go back and try to redo Freeport. You can't do that.
Okay,
but at that point in time, I'm saying that if it had come in on time, I think we would have recommended and you would have granted a Freeport, and they would have been abated the taxes regardless of how much inventory had been made.
That's what I'm saying, they're prohibited under law.
I understand. I'm not. Does the board understand what I'm?
Yes, I understand exactly.
Okay.
But
But all I'm saying is, and we can't get into the law portion of it. It boils down: do you want the company to have the Freeport exemption or not? If you do, then you can grant it through this process that they're going through. And that's my only point. I can't speak to any of the numbers, whether they're correct or not. And it's my understanding we have no way to get into the company's records to determine whether they're correct or not. So we do want you to know that Milwaukee Tools is an extremely important company in our community. They have highly skilled individuals in that facility. And the other thing is that just using my intuition, I agree that they don't have enough warehouse space to have that much inventory out there. And at the same time, this was during the period when everything was being moved to China. So it's highly unlikely that they were sending products from China to Jackson and then to Olive Branch. So even though I can't prove that any of these numbers or anything are inaccurate or accurate, it just boils down to the company is maintaining jobs in the community, and they're very well-paying jobs. And if you can help them, we would recommend that you do that. And that's as far as we can go.
Ms. Carroll? And then I'm going to go ahead.
I was getting ready to make a motion.
Well, Mr. President, with the board's permission, I'd like to come back up and make a final statement to the board, if I may. Thank you.
And as he comes up, I do want to clarify something. And I guess his hairs on my back stood up as he was talking. I want to clarify that the board not only can you not apply the exemption retroactively, but you cannot use the additional information as a tool for attempting to apply the exemption retroactive. You have to, there is nothing in law that authorizes the board to reduce a proper assessment of taxes. So I just want to state that clearly. And
so if we, let me understand now, what part of it, if we wanted to make whatever changes needs to be made, what does the law allow and what is it that it does not allow?
the law does allow for the assessor's office to take the additional information provided by Milwaukee 2 to determine if there was an error in the assessment based upon 2735, 143, and one of those 14 provisions. That's what the law allows. but it doesn't allow you to circumvent or allow a company to get an exemption by circumventing a proper assessment. The assessment is what the assessment is.
And the difference in the figure would be what?
It's huge. The difference in the figure initially reported was 57.62 billion in property movement, which would amount to approximately tax liability in 1.48 billion. The amended petition that they last provided includes an assessment of $2.684 million with a tax liability in the amount of $75,000. So it's huge.
And in comes, before I leave, Attorney Martin summed it up for me at the end. In 2010, what you're looking at, board, between these figures, now we're going to talk about value and actually dollars that you guys need to look at. You would have $1,405,793.61 coming off of your tax roll for 2010.
Well, that figure, have we ever received that amount?
They have not paid, I'm sorry. It has not been paid.
No, I mean, in prior years.
Because the exemption applied in prior
They
years.
have exemption, exactly.
Okay.
Thank you for letting me come back up. Really, one thing of that, for the property that they were not exempt from, Milwaukee has paid taxes prior years.
Wait, pardon?
I said, for the property that was not subject to an exemption, Milwaukee has paid taxes prior years.
Okay.
I wanted to address a few things. I'd like to thank Mr. Stokes and Ms. Bird for coming up. They've been trying very hard to go through a lot of information with them here in the last few weeks. We are appreciative of that. Ms. Bird spent some time talking about the Freeport reports, timing of those filed by Milwaukee in 2010. I guess the only issue I had, the note I made was that, as a practical matter, those didn't matter last year. Technically, Milwaukee should not have even submitted the Freeport report in 2010. They had no Freeport exemption. It had expired on December 31st, 2009. As a result of that, their inventory would have been reported along with all of their other personal property. I brought with me a copy of their personal property rendition file, and I have with that a copy. I think it was first mentioned that it had to be submitted postmarked by the 31st, and we had submitted evidence to the tax assessor's office that that return was postmarked March 31st, 2010. That date really doesn't matter. If you look at that earlier rendition, I know the tax assessor's office has record of this, they had reported far less inventory. This thing's got really confused. I guess that's what I was trying to convey earlier with this notion of were Freeport reports filed on time, why was the exemption applied. Milwaukee has no argument about that. We are in full agreement that there was no exemption in 2010. And the company is more than willing to pay their fair share of full county, city, and school taxes on the personal property and inventory they had at their facility. The one caveat that I have to agree with Attorney Martin, she is 100% correct. The board has no authority to go back in a prior year and retroactively grant a tax exemption. I wish it were that easy. The board, however, does have the authority, though, to direct the assessor's office to correct the 2010 roll to reflect the actual property on hand at Milwaukee's Jackson facility in 2010. That's what we're asking for assistance with today.
He just answered the question on one of his comments on Ms. Martin's statement that the Board of Supervisors could not go back and apply a retro exemption. So he just answered that.
Mr. President, members of the board, I'm not an employee of Milwaukee. I feel a personal connection to the company. I'm a Hinds County resident and live in Clinton. There's plants in my backyard. I think a lot of David and his team there. Nothing that has transpired in the course of all this has been, from my viewpoint, what I can tell, and I do this a lot of other jurisdictions, any attempt by the company to try to get an exemption for a past year or somehow circumvent their tax liability. What we're here today asking for is some relief from the county to avoid assessing a $1.5 million penalty on community business for what was a young lady's spreadsheet. There's no argument on behalf of the company or for me that the mistake was not Milwaukee's, it was not the tax assessors. There's no way when they got that they necessarily could have known that was an error. They got a report from the company, and that report was wrong. The notice that went out in August of last year, you have to correct me, Ms. Rose, if I'm wrong, that has the actual value of the property, not the tax liability, correct? Basically, the problem with this, and the last thing I want to address is, of course, all of these go to Milwaukee's corporate office, not their local office, something that is changing very soon. What went to the corporate office was a statement of inventory. That was the inventory value they had reported in error last year. People who got that are the same people who mistakenly reported $57 million. When it goes to a corporate tax department that manages tax reporting for not only Milwaukee Tools, but there are other brands, Home Light, Ryobi, and other divisions, it unfortunately doesn't draw attention. And that was very unfortunate for the company. When it finally got back down to the grassroots here in Jackson, it became very evident that the number was wrong.
Okay, and I don't want to ask, but you go ahead, and then I want to ask you. Go ahead.
Well, go ahead and ask your question.
Go
Because
ahead.
I'm gonna remember.
Go right ahead.
Can I state one thing, Mr. Pace, as far as the filing and the notice that was sent out? It does reflect the true value, but also if, based on your statement, they did file their Freeport form.
Right.
And the filing, they filed for their Freeport amount, $345,774. Had that been
Yeah.
yes, they would have received a statement on that amount, not on the 57 million.
Well, and
So,
right.
that.
No, I can't disagree
What
with
I'm
you.
saying, you said that because that's what they filed, they may have overlooked that figure based on, because that's what they filed, but that's not what they filed. They would have filed the 345,000.
Understood.
So had the notice gone out based on that amount, that's what would have shown.
The actual the net exemption amount. I guess I'll sort of close on this and make our final appeal to this board. One of the things that has, I guess, possibly negatively come out of this, at least on the company side, is because Freeport reporting in Mississippi is, other states do it, but it's a little bit unique. One of the positive things that has come out of this is that reporting is going to be overseen by Milwaukee locally in coming years. Ms. Burke correctly pointed out that some of the reporting has been remiss starting in 2006. In 2005, Milwaukee Tools was acquired by their now parent company, TTI, which is a global conglomerate. They own lots of home improvement brands and floor care products like Dirt Devil, Ryobi, Home Depot, you've seen Ryobi. And they started managing all of their state reporting process out of their corporate tax department. And unfortunately, the mistake, a very significant one for the local folks, has arisen out of that. I have no disagreement with Mr. Stokes' office that the error was on the part of Milwaukee, not on the part of the assessor's office. They have been very helpful in helping us to resolve this. The only thing we're in here today asking is given the authority granted to this board by statute to amend the prior year return, accurately reflect the property of the water gap, we ask that you please do that. Because once we pay the bill here, we're going to turn around and pay the bill in DeSoto County too.
Okay. And that relief, one more time.
Well, I will read you the statute, Mr. President.
No, not the statute, but the amount of relief.
It would be revising the parcel with the inventory on it in 2010 from approximately $57.6 million to reflect the correct inventory on hand on January 1, 2010 of $2.7 million. I can give you the
And the
specific.
tax amount again is $1 million.
1.48.
750.
256.28.
Right now, the tax statement that's outstanding is $1,481,256.28. The value that they are requesting is $2,684,761, which we would have to adjust with the 2% penalty because
And that would be fine.
that would be $2,953,237, which brings us to a tax dollar figure of $75,462.67. And you have that information in your pack.
Okay. You heard. The argument, Ms. Calhoun.
I'm very proud of the fact that Milwaukee 2 is located in District 3, and very proud of your corporate citizenship for Hinds County. I am there is such thing as having personal responsibility, and part of that personal responsibility has to do with accepting when your employees err. This board, whenever our employees err or make mistakes, then we have to take the personal responsibility for those mistakes. And to guarantee that we take that personal responsibility, the media backs up that accountability. Milwaukee, too, has had ample opportunity to go back and correct the mistake that was made. And for whatever reasons you all have chosen not to go back to correct the errors. But today you come and request this board to direct or authorize the tax assessor office to make the correction for you. The Mississippi Code, as stated, does not allow or prohibits this board for going back and retroactively correcting the mistake that was made by their company. My motion is that your request be denied. I think the remedy to your situation is, again, for your 2011 tax returns, that you apply for a tax credit for the overpayment. And that will provide you the opportunity to somewhat compensate for the error that was made. That way, it would keep this board in compliance with the statute. And again, Milwaukee 2 perhaps will, I don't want to use the word, but just say Milwaukee 2 next year will have the opportunity to go and correct the error that was made.
Supervisor, if I may, I didn't interrupt. Go right.
Yes.
Okay.
Okay.
I wanted to add one thing. I will Attorney Martin to speak if she chooses to as well. You are correct in that the board does not have the authority to grant an exemption for requiring you to go back and grant an exemption. Attorney Martin was 100% correct in that regard. The statute we are seeking, I guess, relief under today is Mississippi Code Section 2735-143, which states, and I'll read it because it's not very long, it says the Board of Supervisors of each county shall have the power upon application of the party interested to change, cancel, or decrease an assessment at any time after the assessment roll containing that has finally been approved by the State Tax Commission and prior to the last Monday in August next, which is
Yes, sir, but we also have other statutes. And I think some statutes supersedes the other statutes and what have you. But this board becomes personally, our taxpayers become personally liable. This board becomes personally liable anytime that we should not respect the codes that have been set forth before us. And I would not like to be, now I don't know how this board is going to vote, but I am stating I'm stating my position.
Well, thank you for that.
And that is that we deny your request. Now, I mean, I get a second.
Had a motion on the floor, and I see we have another hand, but there's a motion on the floor. Do we have a second? Do we have a second?
I'll second it.
It's been moved, probably second down, discussion about this.
What is the difference in what you're saying? You admit that the board doesn't have to,
Well,
to do this, then you turn around and say, but under the statute, I want you to do it. This is basically,
there
what you're saying.
are two entirely different issues. One is a tax exemption, which Milwaukee had on all of its inventory until January 1, 2010. And that exemption went away. Regardless of what their inventory had been in 2010, that exemption, had it been in place, would have negated that tax liability. We're not asking the board today to go back and grant that exemption to exempt the property. Milwaukee agrees that it had no exemption last year and that it should pay its taxes on the property as Jackson facility on January 1, 2010. The specific statute that I read a moment ago is designed expressly for that. It grants the power to county boards to go back and change the assessment rules, the value or the type of property or the numbers of properties on the prior year's tax rolls, and for one of 14 different reasons. The two primary ones that we petitioned the board under were, number one, that property was never existed or was not owned by or in the possession of the party to whom it exists in the county. And based on the company's reporting, the property that reported in the error in Hinds County was physically located in Olive Branch and is subject to property tax in DeSoto County. And number two, the same property is going to be assessed twice, which is the first reason that the board is authorized to go back and make this change. Because if the board elects to move forward, not change the value of property on Milwaukee's rolls for 2010, it's going to be subject to tax in Hinds County, and that same property is going to be subject to tax in DeSoto County. So Milwaukee Tools will in effect pay property tax on the same inventory twice in Mississippi.
Yes, sir. Now I have a question for the attorney. But again, you have the opportunity with the other municipality to also file for a tax credit on your 2011 tax returns. You will get your tax credit, but I would think, out of consideration for this board, that you would move forward in accepting the responsibility that you erred, and that you have the opportunity next year to apply for your tax credit, and that would spare my colleagues, the ones that choose to vote for your proposition, that would spare them from any liability and personal liability. But my question is this to the attorney, or Ms. Martin. If a board member makes a motion to allow any given situation or any given matter, for example, this situation, and then when it comes to the claim docket, that same board member votes against that claim docket, is that board member responsible or liable for the motion that was made?
My understanding of what you asked is, if there's a motion made and to accept a certain expenditure, and during the claims docket, that member
Votes against the entire claim docket, does that expense become a liability of that board member?
I believe there's argument with the state auditor's office at the time the member voted for the expenditure, a liability would attach.
even if it goes against paying that expenditure.
Correct, that would be ultimately a question for the state auditor's office, but there's at least an argument.
Yes, I think it is important for this board to know what the affirmative is in that regard.
And with regard to 2735 1.3, again, I would like to reiterate, there is nothing specifically on point with regard to this. But in the argument made by the county against AmSouth, the argument was since there was a mistake by the taxpayer, then the board chose to accept the recommendation of the tax assessor's office and to deny the request or the petition for a reduction of value. Now, the circuit court actually affirmed or agreed with the motion, the county's motion to dismiss that situation, but ultimately we don't know what the court would decide. But you at least have a precedent where circuit court has ruled favorably when the county decided to not exercise this option when it's been a mistake of the taxpayer.
Okay. Yes, sir.
Could I get a clarification on the motion that was made?
Okay. Go ahead.
To deny the petitioner's request.
Okay,
And
just to deny. Okay.
And to accept the tax assessor recommendation. And the reason, again, to not just being in compliance with the law of the statute, but likewise, this petitioner has the opportunity to correct that mistake that was made with Milwaukee's 2011 tax returns. And I'm sure the tax assessor could work with you to correct that error, and we would be, again, in compliance with the statute.
Okay.
And I just wanted to, as we were discussing possibility of double assessment, to the best of my knowledge, there's been no amendment petition to DeSoto County, for instance, to increase the value. So at least we request that if this property is truly part of DeSoto County, there be an amended petition to DeSoto County, just like there was an amended petition for reduction time.
Okay.
I can speak that we notified DeSoto County of that last week. At the same time, we notified Hinds County. We have not yet filed a petition. We're still sort of the first stage of discussing the issue with their assessor's office. After we discovered it was the Olive Branch property before here.
Okay, it's been moved, proper second discussion, discussion, all in favor say aye.
Aye.
Opposers? Motion carried.
We look forward to seeing you next year.
Okay. Any other trustee?
That sits so long, I forgot. I almost forgot. I had one other item on the agenda, but I had some additional research with regards to oil plus and requests to bring it to another meeting.
So you don't want to, you're not going to discuss the other item?
Correct.
Okay. So
Does that affect anything as far as the tax assessors are concerned?
No, sir.
okay. Any other item come forward with that? We'll ask for a motion to adjourn.
So,
We can move. Do we have a second? A second and move, proper second discussion. All in favor say aye. Opposed, the motion carried. We now stand
I'm
I understand.